6 keys to a winning opening statement coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you. If you're a repeat visitor and a subscriber, very grateful for that, and thank you for joining once again. If you're not, and maybe this is your first time coming to my channel and watching one of my videos, then to learn a bit more about me and my credentials, you can check out the video on my homepage, and then feel free to hit that subscribe button and the notification bell so that you don't miss any future videos that can help you win in small claims court. And with all that said, let's jump into today's topic, which is the 6 keys to a winning small claims court opening statement. Now, what do I mean by an opening statement? Well, what we're discussing here is when you've gotten to the stage of being in court for the trial or wherever the small claims court hearing is held in your jurisdiction. In most jurisdictions, it will be held in an actual courtroom. In some places, it will be held in a conference room. So it really depends on your jurisdiction. But let's assume for this purpose that the small claims court trial is being held in a courtroom. So you're at the court and the judge, the decision maker, again, making some assumptions. Very hard to speak to a worldwide audience because different small claims courts around the world have their own set of procedures. But generally, in most small claims courts around the world, based on my research anyway, is that the small claims court's decisions will be made by judges. Okay, now there are various levels of judges. Some are called deputy judges, such as in Ontario, Canada, where I'm from. But the point is that we're going to refer to the decision maker as the judge. So the judge calls up your case and they tell you, okay, begin, start. Sometimes it's as informal as that. Okay, it's not like the movies or anything like that. The judge will just say like, okay, go ahead. And so you need to decide how you're going to actually start your lawsuit or start the presentation of your case in front of the judge. And in my experience, the best way to do that is to have a prepared opening statement. Not every court will allow for this. Not every judge will ask for it or want it. But in most cases, the judge will be all too happy to hear an opening statement from you, which is a great chance to give the judge a summary, if you will, of what the case is about and what the judge can expect to hear, what the judge can expect to see by way of evidence, and etc. I'm going to get into that when I go through the 6 keys, but that's the point of the opening statement. And really, your opening statement should be prepared in advance. The best is to have it on kind of 1 page, not too long, because you don't want to bore the judge or mention anything that's not relevant to the case. So you want to try and keep your opening statement to 1 page, and that preparation is best done before. And with these 6 keys of knowing what it is that you're going to be saying in the opening statement, you can kind of work backwards or reverse engineer to know how to prepare your opening statement in writing. I do have plans in future videos maybe to do a brief workshop in terms of how to actually write out your opening statement. But for now, we're talking about where you're actually standing in court and you're going to make your opening statement. Another caveat I should throw in as well, I've done this in a bunch of videos, is that I'm coming at this from the angle of you who's watching this video is the plaintiff, the one who's suing. I think the vast majority of people coming to my channel and watching the videos are people who are looking to actually sue or win their lawsuit in small claims court. But obviously, a lot of you out there who are watching this may be defendants, and you're just as entitled to have help in small claims court. And don't fret. A lot of the tips and guidance that I give, even if I'm coming at it from the angle of a plaintiff, could obviously be applied to you as a defendant as well. Of course, my intention is to do videos geared specifically towards defendants as well. When I was a practicing small claims court lawyer before I retired, I obviously helped both plaintiffs and defendants alike. So with all that said, let's jump into my usual old school whiteboard that I've prepared here. And we're going to talk about our 6 keys to a winning opening statement for small claims court. The first key that I've written down here, if you could read my handwriting, it's amazing that I'm an attorney, a retired attorney anyways, and not a doctor with my scribbly handwriting. But the first key that I've written down here is the elevator pitch. Now, what do I mean by elevator pitch? So an elevator pitch is, let's say you're in an elevator and you meet somebody who you want to sell your business to. You've got a couple of floors before the person in the elevator gets off, and you have to present to them what it is that your business does and why they should invest in your business. So that's a common definition of an elevator pitch. Obviously, there's various variations depending on what industry you're in and what business you're in and what you're trying to get out of your elevator pitch. We don't have to go down that rabbit hole. But the point is that the elevator pitch is meant to be a very brief synopsis of what it is that you're trying to convince the person across from you to do or to believe or to see, how to behave, etc. So I call this elevator pitch because this is the very first thing that you're going to say to the judge to start your lawsuit. And what you want to do is that you want to simply capture your entire case in one statement. So let's take an example using the imaginary case that I've used in other videos. I may be interchanging the names, so forgive me if I'm doing that, and any reference to actual names is purely coincidental. But let's take the name of Jim's Landscaping, and you're Jim Smith. You own Jim's Landscaping, and you are suing Frank Jones. Okay, so what you want to say to the judge to start off is your elevator pitch. You say, Your Honor, I performed landscaping work for Frank Jones on December 1st, 2023. Frank Jones failed to pay me, and therefore I am suing him for $10,000. Simple. Okay, the judge already knows that this is a landscaping dispute, that you are the landscaper, that you say that you did the work for Frank, and that Frank didn't pay you. It's a very simple snapshot of what's going on, and that puts things in perspective for the judge. Now, you may be thinking to yourself, well, this is obvious. Well, you would be amazed, and I've watched many other cases in action. A lot of times in small claims courts, before your case is called, you watch other cases as they proceed. And I've seen many cases where parties get up and they're just all over the place from the get-go. I find myself asking myself, like, what in the world is this guy talking about? I don't understand anything about his case. So you can imagine what a judge is thinking. Now, obviously, a judge maybe has read the documents beforehand to get a bit of a sense of the case. And that's very important as well. You should know as a plaintiff to have a good statement beforehand, setting out why it is you're owed the money. In some courts, you have less of a chance to explain your case than others. In Ontario, for example, you have what's known as a plaintiff's claim, where you can set out exactly why you owed the money, what transpired, etc. Whereas I saw, for example, in the New York small claims court, it's more of like a pro forma, like a templated type of form where you just state the nature of your claim. And if that's the case, by the way, where you don't really get to set out in the court documents before you get to the trial what exactly the case is about, that's why it's even that much more important to have that elevator pitch ready so that you can tell the judge instantly in a matter of seconds what your case is about. Okay, so that's your elevator pitch to start off your opening statement, and that's key number one. Key number two is telling the story. Okay, now it's not just a matter of telling the story, it's telling the chronology, and also in a concise, effective, efficient manner, not straying off into irrelevant details, personal vendettas, things that the defendant may have said, or things that angered you, your emotions surrounding things. No, it's about giving the chronology to the judge. So again, to go back to our example, we've got Jim's Landscaping suing Frank Jones. So Jim will start off by saying, on November 1st, again, I'm interchanging dates, but you get the point of what I'm trying to accomplish here. On November 1st, 2023, Frank Jones hired me to do landscaping at his property, which is located at 99 Cucumber Lane. On November 1st, 2023, we also entered into a contract that stated what the terms were of the landscaping services, and both of us signed the contract. And by the way, I'm going to get into later in the keys how you should reference the evidence when you're going through your opening statement, but I just want to stay with the key number two for now, okay? So back to the chronology that you're going to give to the judge. On November 2nd, this happened. On November 3rd, I went to Frank's property and performed the landscaping services. On November 5th, I sent an invoice to Frank Jones for payment, and after 30 days passed, Frank Jones failed to pay, etc., etc. So you're really going through, by referencing the chronology and the relevant dates, what happened and when. Okay, so that's the second key. And that kind of ties in with the key number three, as I alluded to just a moment ago, which is, as you're doing that, you're going to want to reference the evidence that the judge is going to see. Now, the opening statement is not the time to actually go into your evidence in depth. By the way, in case you're wondering what evidence is, evidence really consists of, for example, the contract, invoices, emails, documentary evidence, documents that you have to prove your case. In this day and age, documents could also mean transcriptions of recordings. It can mean actual listening to recordings, depending on the court, if they allow that, audio, visual types of things, text messages, messages like that. Okay, that would be your evidence. It also consists of testimony, okay, what the witnesses will be talking about. So evidence consists really of those two things, to keep it simple for this video. You've got your documentary evidence and you've got your witnesses. So as you're going through the chronology, you're going to want to reference your evidence. So going back to what I was saying before, you would say, for example, on November 1st, 2023, I entered into a contract with Frank Jones to do the landscaping work. The contract that we entered into was for payment to me of $5,000 upon completion. And Your Honor, I will be submitting to you the contract as proof of this arrangement that I had with Frank Jones. By the way, I talked about in the earlier video how you want to have an evidence brief prepared before trial as well, so that when you're referencing your evidence, it's that much clearer for the judge. So you'll have it, let's say you'll have an index of all the evidence, and you'll say at tab 1, Your Honor, I will be going through the contract to demonstrate my claim. Going back to the opening statement that we were talking about, so let's say the next thing you say is that on November 2nd, 2023, I went to Frank's property, and Your Honor, I have in my evidence brief at tab 2 photographs of the property that I took when I was at his property for the first time, to give you an idea of what the property looked like before I did the landscaping. Your Honor, I also have a witness, Sally Jones, who's going to be testifying on my behalf that she was there at the time of when I went to the property for the first time, and she will corroborate, she will validate the evidence that I'm showing you in terms of the photographs to say that, yes, this is what the property looked at beforehand. Okay, so that's an idea. As you're going along with your statements, you're alluding to the evidence that the witness will give, the evidence that your documents, the story that your documents will tell. But you're not going to go into it. You're not going to say to Your Honor, I'm now providing to you the contract to have a look right now. No, you're not doing that. The opening statement is that. It's an opening statement, but you're not delving into the evidence at this point. Okay, so that's the difference, a very crucial distinction. You're alluding to it, you're referencing it. That's why I said the key is to reference it, but you're not going into it in depth. You're letting the judge know that you will be going into that once you start giving your evidence, once you start actually going through your documents and actually asking your witnesses questions. And we're going to get into asking questions of witnesses in a future video. So those are 3 keys. Key number 4 that I have jotted down here is to cite the law. Okay, now this isn't for everyone and for every small claims court. A lot of times the reason you're in small claims court is precisely because you're a layperson. You're not an attorney, nor are you expected to be one or to be able to read law or to understand law or to apply law to your case. But there are many small claims court, again, once again, my hometown, so to speak, Ontario, Canada, where you are able to reference law. And there are legal databases, especially as technology continues to expand and to grow, where a layperson does have that at his or her fingertips to be able to access the law. So in cases like that, I threw this in as the 4th key because it can be very important if there is a specific law that allows you to be claiming what you're claiming. Okay, now getting into specific laws, I'm not going to do for the purpose of this video. I feel like that may bog down many of you who this may not apply to. But for those of you who this does apply to and you are relying on law, now in your opening statement is a good time to state very briefly what the law says about the case that's happening and how you're going to rely on that law to prove your case. And once again, it should be a very brief statement. You're just citing the law, you're mentioning it, but you're not getting into it. In your closing submissions, okay, at the end of after you've given your evidence and the witnesses have testified both for you and also the defendant, then in most small claims courts around the world, you will have the chance in your concluding remarks to start referencing the law and what the law says about your case. But to allude to it in your opening statement is a very advisable thing to do, and that's why I've put it as my 4th key. And once again, if you are not in a courtroom where law is actually relied upon, or you don't know anything about law, then don't fret. Plenty of those self-representing themselves in small claims court are going without any sort of law and are not expected to have any sort of legal knowledge for the purpose of their small claims court. So it really depends on which small claims court jurisdiction you're in. Key number 5 that I've noted down over here is to refute the defendant. Okay, just get it into the video over here. Refute the defendant. So again, you're not going to get into a whole long story of why the defendant's position is untenable and why you disagree with everything that the defendant says. But hopefully by now, either because the defendant submitted a response or a defense to your claim and you got a sense of what the defendant is saying, or maybe the defendant once sent you an email or text messages where the defendant says, I'm not paying you anything because of A, B, C, D, E, F, G, etc. Then now you can sort of give a snapshot of why you're going to refute that evidence. So for example, maybe Frank Jones had sent you a text message to say, this is the crappiest job I've ever seen, and there's no way I'm paying you anything for it. So what you can say in your opening statement is, Your Honor, Frank Jones is going to claim that I did a bad job and that's why he's not paying. But Your Honor, and again, you reference your evidence again to refute the defendant, I should mention. Your Honor, I have an expert report at tab E of, Harriet Willowford, I just came up with that name on the spot, who is an expert engineer, as I'll go through her credentials at the trial, stating that my work was actually excellent workmanship and there is no reason to believe that it was shoddy in any way. Okay, so now is the chance that you could kind of try and steal the thunder of the defendant in your opening statement. You're showing the judge that you're aware of what the defendant is claiming, but not to worry, Your Honor, I am going to undermine everything that the defendant says. Now, again, you have to be careful. There are courts where the judges may get a bit impatient with this because they may say, hey, now's not the time for you to talk about the defendant. The defendant will have a chance to talk about their own evidence. You just focus on your evidence. And if the judge does it, then that's fine. You kind of pivot. And remember, in my last video, I talked about expecting the unexpected. So in fact, this may be somewhat expected based on my experience. Sometimes you do get judges who don't have patience for you referencing things that the defendant will say because that's something for the defendant. So you can try it. Not to worry if the judge says that they don't want that, you can kind of pivot the other way. So you don't have to be kind of bound to everything that I'm saying here, that it must go in the precise way that it's expected. But in most cases, when you're giving an opening statement, the judge will give you that leeway to make those arguments against the defendant. Again, so long as you don't get too in-depth into it in your opening statement, leave that for the actual evidence and testimony stage of the trial. And finally, key 6 that I have noted down here is for your conclusion at your opening statement, which is to restate. Okay, restate your elevator pitch, really. So what you would say is, so Your Honor, based on everything that I just said, based on the evidence, based on the witness's testimony and the law, that is why I respectfully submit that I am owed $5,000 for the landscaping work that I did for Frank Jones, which he failed to pay for. That's it. Okay, once again, why are you doing that? Because you're bringing the judge back to the central point, which is why you're suing in the first place and why you're suing Frank Jones. So the restatement key number 6, if you will, at the end is to kind of gift wrap everything for the judge so that it brings it all together. It really ties everything together. Any of you are big Lebowski fans out there, remember that rug, it really tied the room together.
Yeah, it really tied the room together.
Restatement of everything that you talked about before is tying everything together. And again, the point is if you see the theme in my video here, keep it short, keep it simple, keep it concise. Don't bog down the court, don't bog down the judge, don't get overly detailed. Now's not the time. This whole opening statement shouldn't take more than a couple of minutes maximum, because if you're preparing it beforehand, which I recommend, as I said at the outset, it only should be maybe a single page, single spaced. Obviously, every case will depend on its facts, but in my experience, almost every small claims court can really be whittled down to a single page. It really is that simple in most cases, okay? Even the most complex sounding cases, really what's happening is that the parties are making it more complex than it really is. I do understand that attorneys are better, maybe not every attorney, and not every self-represented party is less better than an attorney, but I do understand that in many cases, the attorney is better at getting down to the core of the issue. So I'm not trying to make you feel pressure by being self-represented that you cannot do that. You can, you will be given some leeway, but that is your goal, to try and whittle down your case, particularly in your opening statement, to the most relevant details, chronology, evidence, law, and summarizing that all in tying that together with a final restatement of your elevator pitch at the outset. Okay, so once again, just to summarize you see I'm tying it together now, which I always like to do. I always like to do a summary at the end to summarize our 6 keys to a winning opening statement. Key number 1 is that elevator pitch, to give the judge that snapshot from the outset, what this case is about, who the parties are. Number 2 is to tell the story, and that involves having the chronology, referencing the relevant dates. Remember, relevant dates. Number 3 ties in with that, is to reference the evidence. So while you're going through that story, you're going to reference the evidence that you're going to be relying upon, whether that's the contract, the invoices, the witnesses that you're going to have testify. Key number 4 is to cite the law. Again, that may not be applicable to everyone, but if you are in a small claims court jurisdiction that allows for referencing law, then the opening statement is a good chance to reference that briefly. Key number 5 is to refute the defendant, remembering that if you are in a court where the judge kind of gets impatient with that or says now is not the time, that's okay. You can pivot from that. But in most cases, in most courts, you will have that opportunity. And obviously, if you're in a situation where you have no idea what the defendant is going to say because you've never received a response from the defendant, that obviously will make that more difficult. But in most cases, you will have an idea going into the small claims court trial what the defendant is likely going to say based on maybe things that the defendant either filed with the court or said to you in the past. And number 6, finally, is to restate that elevator pitch that I referenced in the beginning to tie the case together. Hope you found that video helpful. Once again, a reminder, if you don't want to miss a future video, then to hit that subscribe button and the notification bell. It takes a second, and it definitely helps me as well to continue producing videos like this for you. My goal is to help you win in small claims court. Obviously, any and all feedback is also welcome. Did you find this video helpful? If you did, why did you? If you didn't, or you would have liked to hear something else or more clarity, I'm always welcome to constructive feedback. And so that wraps up this video on the 6 keys to a winning opening statement. Until next time, I'm looking forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.